My name is Brian Fishman. I'm a criminal defense attorney based out of Philadelphia. I represent individuals, however, in Philadelphia, Montgomery, Delaware, Bucks, and Chester County. Today I'm going to talk about what a motion to suppress is and how it can be used effectively by a criminal defense attorney to defeat a case before it ever gets to trial. Specifically, I'm going to talk about it in the context of possessory offenses, such as when you're charged with possession of a firearm or possession of drugs. We all maintain certain rights of privacy, where the police are not allowed to simply search our person, our car, or our home simply because they want to. They have to abide by constitutional protections. Under the U.S. Constitution, the 4th and 14th Amendments protect the people, and under the Pennsylvania Constitution, Article 1, Section 8 protect us all from unreasonable searches and seizures. The police must have reasonable suspicion to believe that criminal activity is afoot or that you're armed and dangerous in order to pat you down. And furthermore, they must have probable cause to believe that you committed a crime in order to conduct a full search. If they don't have that information or those facts that lead to reasonable suspicion or probable cause, then evidence that was obtained during an illegal search can be suppressed or excluded from evidence. Even though they may have gotten those illegal drugs or guns off the street, still the evidence in court would be excluded. So let's say, for example, you're charged with possession of a firearm, and the police say that they conduct a traffic stop where you are pulled over because you failed to put on your turn signal. The police approach your car, they ask for your license, registration, and insurance, and they ask you to step out of the vehicle. At that time, they ask you to put your hands up and get against the vehicle, and they start to pat you down. They feel a hard object by your waistband, and they search you, and they recover a firearm. Obviously, they arrest you for those possession of a firearm without a license charge, and the case goes to court. Now, the police had the right to pull you over if it's believed that you truly did not use your turn signal. Assuming that is correct and the stop was proper, the next question is, did the officer have the right to pull you out of the vehicle? Well, police in Pennsylvania do have the right, if it is a proper car stop, to ask you to step out of the vehicle. The next question is, did the officer have reasonable suspicion to believe that criminal activity was afoot to pat you down, or did they have probable cause to search you? In the scenario I just provided, there appears to be no probable cause or reasonable suspicion, and therefore the search appears to be illegal. Now, because that happens out on the street, does not mean that that's what the police officer will testify to. The police officer may testify that the back window of the vehicle was heavily tinted when they pulled the vehicle over, and that they weren't able to see into it. And then upon approaching from the side, they saw you making what we call furtive movements. They saw you bending down towards the bottom of the car and making strange movements like you were trying to hide a gun or drugs or some sort of weapon, or even worse, perhaps reaching for some sort of weapon that could hurt them. They also say that when they approach, you're acting nervous and you're not being cooperative with them. You're not providing them with your proper name. You're not giving them information. They ask you to step out of the car at that time, and perhaps they see a bulge now at your waistband. Now, at that point, they would have reasonable suspicion because now suddenly you're acting in a different manner. They can't see into the vehicle, so there's concerns about the officer's safety, and now they see a bulge or a large object which they believe to potentially be a firearm. That may give them the necessary reasonable suspicion to pat you down. And then once they feel that hard object, they will say that they know under a plain field doctrine that that was a gun and they will recover it. However, what happens out on the streets and what they testify to in court is often very different. A lot of times they will pull you over and simply ask you to step out of that vehicle, and they will search you illegally as indicated in the first example. But you need to be able to prove that. It takes a experienced and seasoned criminal defense attorney to cross-examine the officer to prove inconsistencies in testimony to question their credibility. Furthermore, if you had a passenger in the vehicle, that would be an excellent witness to bring into court to testify that you didn't do anything, that the car did have proper tint on it, and that you didn't act nervously or move around when the officer says they did. So that is one other way to challenge the officer's credibility and to try to have the motion to suppress granted. If you've been charged with a possessory offense, such as possession of drugs or guns or any other illegal contraband in Philadelphia or the surrounding counties, I invite you to visit my website at the below address and contact me for a free consultation to see whether or not you have a legitimate motion to suppress and to fight your case. Thanks, and see you next time.